to have. Let's talk procedurally. There's a motion to disqualify. There is an opposition to the motion to disqualify, and then there is a reply to the motion to disqualify under procedural law. But not to Mike Roman and his lawyer Ashley Merchant. They just created a new piece of paper. They said, well, we have to immediately respond, and it's not our substantive and complete response, but we need to respond because they're trying to get out from under the evidentiary hearing. And so I get 5 more pages today that I'm not supposed to have in another type of reply. If I were Scott McAfee, I would either, and if I were Fonnie Willis, I would either move to strike this piece of paper that's just been filed as being an improper brief, or make them have just that brief but nothing else. They say in a footnote, well, we're going to argue more substantively, but we needed to address the issue of whether there should be an evidentiary hearing. Who asked you to do that? The judge didn't order that. The judge didn't ask for more briefing. You just gave it to yourself, which is another example of just the media attack that you're launching here, the tactical attack that has no legal basis. Mr. Roman, Miss Merchant, I mean, the emperor has no clothes. I can tell by reading, and I'm going to read it out loud to you, the parts that almost made me laugh out loud. This effort to give yourself a new brief that you're not entitled to. Scott McAfee, who's a very good judge, and we've complimented him here on the Legal AF podcast and on Midas Touch and Shut It All Down. Let me read to you from this, I don't even know what to call it, this scurrilous piece of legal writing. You know your audience, which in this case about it, until they got caught with their hand in the cookie jar. This highlights the very reason why this court cannot just take their word for it. First of all, the judge has already said he's holding an evidentiary hearing, right? Meaning he's going to take evidence. He's going to take sworn testimony and from witnesses and the like. But listen to the phraseology here, right? And how scurrilous and scandalous it is, and so lacking of any intellectual heft as to be, should just be laughed at of court. Mr. Roman, if Mr. Roman had now uncovered the now admitted personal relationship, I'm going to say this for one more time on the Satik. There is nothing in the Georgia Ethics Code or the Special Prosecutor's Ethics Code that stops a prosecutor from having a personal relationship with somebody else on her team that's also prosecuting the same case. Just as there's nothing wrong with people having relationships who represent other witnesses or other co-conspirators in the case who may be at odds, but then at night have pillow talk together. Or be married. You can be married. A prosecutor can be a prosecutor on one side, defense lawyer on the other. You can be married on opposite sides of a case, and that's okay. The law expects people to have intimate personal relationships, but it doesn't assume that people are going to violate their professional ethics just because they're also having a relationship with somebody. Did you know that your temperature at night can have one of the greatest impacts on your sleep quality? If you wake up too hot or too cold, I highly recommend you check out Miracle Made's bed sheets. Inspired. Mike Roman is a co-conspirator charged with a handful of felony counts for intentional and those in other states as the election day supervisor for Donald Trump. Have you ever, in the history of criminal justice, heard of a criminal defendant, complaining that the prosecutor on the other side is not qualified to prosecute him? That the prosecutor doesn't have enough experience, that he demands a more qualified prosecutor? Who is this person? He seems to be an immature, amateur, incompetent. Bring me a more powerful prosecutor. Has that ever been said anywhere, anytime by a criminal defendant? But when you read Mike Roman or his lawyer, Ashley Merchant, they actually take another pot shot on page 3, and they say the state's response also states that Mr. Wade, that's the special prosecutor who was hired by Fonnie Willis, and the relationship started after the indictment was started, not before, a point that's not even addressed here in this paper. They say that if Mr. Wade had significant trial experience, if his experience was so significant that he should welcome the opportunity to testify as to the specifics of the cases he's tried and enjoy the candid transparency that would bring to the process instead of hiding behind an unsubstantiated claim that he's tried complex matters like murder, rape, armed robbery, aggravated assault, drug trafficking. Put it plainly, he has given this court and the public no reason to take his word for it. Again, I challenge Ashley Merchant. I believe that was written by Mike Roman. I've seen his writing before. This looks like it was ghost written by him. And here again you have on its face a criminal defendant demanding that a more qualified and more experienced prosecutor prosecute him. Oh my God, this is like out of Warner Brothers. You know, it reminds me of that episode between Daffy Duck and Bugs Bunny, when they were arguing over whether Elmer Fudd should shoot them there or they should shoot them when he gets home. I mean, it's just mind-boggling, but it just shows you the depths of the depravity to which they will sink in order